Good afternoon, everyone. Welcome to the Conference Committee on House Bill 2070. Thank the Senate for agreeing to meet with us. It's been a minute since we've looked at this bill together, and so my thought for starting off would be to have the reviser go through the differences between the two bills. So I ask you to do that, Jesse.
Thank you, Madam Chair.
I do have just a question, if I may. So I think the differences we're going to be hearing about, as I recall, we had Senate sub for House Bill 2070, and then there was a House bill, a different one, 2443, that was kind of what we were looking at last year, if I remember correctly, or am I not correct on that one?
That would have been the bill that we passed. Yes, that's
Okay.
a comparison. It's the bill that was passed out of the House. And then we were working on 2070 as our base, and that is the Senate bill that passed. So we each passed a different version.
Okay, and that's in the night.
Yeah. So. Thank you for pointing that out.
Thank you.
Okay, Jesse.
Sure. Thank you, Madam Chair. So for clarity, the chart in front of you has Senate Bill 115 and then the Senate sub for House Bill 2070. So I'll go over those. And then as we talk about 2070, I'll discuss the differences between Senate sub for House Bill 2070 and then the House Bill 2443. But we don't have those materials on that later comparison provided today. So that's something we can gather electronically for later if requested. So Senate Bill 115 changes the list of persons who are required to be given notice at the hearing on a petition for an independent or step parent or private agency or public agency adoption. So it changes some items such as notice is not required to be given to a person whose parental rights have been terminated or a person or agency that has waived the right to receive notice. So Senate Bill 115 was amended into House Bill 2549 on the floor of the House this session, and 2549 with that Senate Bill 115 has passed both the House and the Senate, is on its way to the governor. So that's the current status of 115. So for Senate sub for House Bill 2070, this bill does a few different things. First, it establishes the Office of the Child Advocate as an independent state agency. It makes certain orders granting custody for adoption subject to the Federal Indian Child Welfare Act, directing the Secretary for Children and Families to consider foster parents as prospective adoptive parents in certain circumstances, and authorizes appeals of an order of a placement of a child. So that is the current version. House Bill 2070 was first introduced in the House, and it first amended 216824, which would allow non-drug offenders convicted of severity level 7 through 10 felony with certain criminal history scores to participate in a drug abuse treatment program. So those contents that were originally in 2070 were put into House Bill 2010 during conference last session, and it passed in that conference committee report. So you can find those changes in the current version of 216824. If anyone wants that session law reference, is the 2023 session laws, chapter 93, section 4, where you can see that conference committee report and those changes. So the Senate version, the Senate sub for House Bill 2070, which is the bill before you today, and you can find these items in the bill provided to the conference committee. It removed those contents of 216824 and inserted contents of Senate's or substitute for Senate Bill 232. So in the bill before you, sections 1 through 6 establishes the Office of the Child Advocate, the powers and duties, confidentiality related to access to documents, and prohibitions on retaliation. So going further into this aspect of the creation of the office, some of the differences between House Bill 2443 and then Senate sub for House Bill 2070 are going to be first, in the House Bill 2443, there's different definitions of what a child is. So on the House side, child means an individual under 18 years of age who is in the custody of the secretary, may be alleged to be a child in need of care, is alleged to be a child in need of care, and is currently or was receiving services from the treatment from DOC. Whereas in the bill in front of you, child means an individual less than 18 years of age, is in the custody of the secretary, was previously in the custody of the secretary, is alleged to be a child in need of care, is or was receiving services from DCF or any contracting agency, has an open case file, or has been, or whose siblings, parents, or other characters have been subject of a report or abuse or neglect to the Kansas to DCF in the past 5 years. So this later part of this is a bit more of an expansive definition of child. Both bills place the office as an independent state agency. In 2443, the child advocate was subject to oversight and review from a child advocate advisory board. The appointment of the child advocate in the two bills: on the House side, the child advocate advisory board appointed the child advocate, and it was subject to Senate confirmation. In the bill before you, the child advocate shall be appointed by the governor and subject to confirmation by the Senate. Some position requirements and restrictions on the child advocate. On the House side, a person that either holds a current relevant license that would authorize the individual to work as a licensed professional, as a case manager, behavioral health professional, or attorney, or has 7 years of experience. No current employee or an employee within the past 12 months of an executive agency or manager of any entity subject to oversight of the office could be the child advocate. On the bill before you, no former or current executive or manager of any program or agency or contracting agency subject to oversight by the office within the past 6 months of that individual's period of service can be the child advocate. So the difference is there is the same person. We're talking about the same person, but the House bill puts the not in the past 12 months, and the Senate bill puts not in the past 6 months. The bill before you has specific language that the child advocate be selected without regard to political affiliation and on the basis of integrity and capacity to effectively carry out the duties of the office. House version would have 4 years of a term. Senate version would have 5 years of a term, or until a successor is appointed. There's no salary addressed on the House version. In the bill before you, the salary is set as an amount equal to the annual salary paid by the state or a district court judge. Funding for the office on the House side would be own budget approval, own budget and approved by the advisory board created by the bill. On the Senate side, it would be own budget upon the approval of the Joint Committee on Child Welfare System Oversight. There are some different reporting requirements, such as, an annual report to the governor, the House of Representatives, certain standing committees. So both sides have reports going out. The Senate side has that there are the report to be sent to also the Chief Justice of the Supreme Court, the OJA, the Secretary of DCF, in addition to the committees, the governor, in the House version. And then they also have differing, word for word on the purpose of the office. So for the House version, to ensure that children and families receive adequate coordination of child welfare services. And then on the Senate side, the purpose of the office is to ensure that children and families receive adequate coordination of welfare services for child maltreatment prevention, protection, and care through services that are offered by DCF and contracting agencies and juvenile courts. There are differences between the interactions that the office shall have with the judicial branch. So on the House side, the Office of Child Advocate may file any of the office's findings or reports regarding a parent or child with the appropriate court that has jurisdiction over the child in need of care case involving the child. And they may issue recommendations regarding the disposition of an investigation into the court or to the investigating agency, but is prohibited from intervening in other cases that may, relate to a child, such as divorce or protection from abuse or a juvenile offender case. They have the authority to utilize resources from the AG's office. And then in the Senate version, which is in front of you, the office is not required to testify in any court with respect to matters held to be confidential in the section. The court may deem necessary to enforce the provisions of the Child Advocate Act, and therefore they could compel the office to testify in those types of actions. They may work with juvenile intake and assessment workers, juvenile community correction officers, guardian ad litems, and court-appointed special advocates. It also allows the Attorney General to file in sync cases on behalf of the office. They also provide record confidentiality aspects. As far as any additional items that one bill has, the other one doesn't. The House side does have this advisory board, such as the members shall be appointed by the governor, the chief justice, and the leader of both the majority and minority parties of the legislature. The bill in front of you does not create that advisory board. Both bills do contain prohibitions against retaliation, and then both bills include revisions to the current sync code and JO code as far as allowing access to the Office of Child Advocate. So those are the differences between House Bill 2443 and House Bill 2070. I apologize that we did not provide a document, having the differences between these two rather than the chart provided earlier, but that's something we can provide to the committee.
Thank you for the thorough explanation, Jesse. We do. Some of us have this side by side from last year. Could we get some copies made of this? No, but it's from our conference committee.
Yeah, so we're going to print copies of that. And that's going to reflect the same exact copy that we handed out last conference.
Okay, so would you prefer to wait till we have this side by side, or you want to get started with some
Yeah, I'd like to start talking if we could, since we're kind of working off of Senate substitute for House Bill 2070 as our base bill, as Madam Chair had indicated, and I had taken a look at this for the Senate side of things. And, one of the first things we heard is, definition of child. What are we even talking about when we're talking about Office of Child Advocate? And we did hear that there are some small differences about definition of child, while a lot of it is the same, an individual less than 18 years of age. And they're pretty similar. So what the Senate would offer is we can accept the definition of child that's in I guess it's House Bill 2443, but we need to stick some guardrails in there, I would say, and guardrails as far as look back period. I mean, you might have been a child who was in the custody of the Secretary for Children and Families while you were, up to 23 years old, but you are now 42 years old or 47 years old. And we want this Office of Child Advocate to be primarily focused on kids. And I don't think the purpose of the office is to be a 40-year-old person who was once in the system, and then you're asking the child advocate to look back. So the Senate offer would be that you have been either currently are receiving or had received services or treatment from the Department of Corrections or the Secretary for Children and Families. I'm sorry, for Secretary of Children and Families within the last 5 years. So that would include, you're up to, I guess that would be 28 years old, because you can be in the custody of the secretary, I think, till you're up to 23, if I have that correct. Do I have that correct, revisers?
So what line are you wanting
So
to
on page, actually it's pages 1 of both of the bills. Mm-hmm. And I would ask the reviser to put a balloon together that takes the House definition in 2443 and adds some language that this all applies if you are within the custody of the secretary within the last 5 years. Does that make sense? So that would kind of be on page, so it'd be line 17 on page 1.
You're looking at
2443 on page 1. Or actually, it's pretty similar to what's in 2070, but willing to accept the House definition and then just add in but you have to have been within the last 5 years involved with the system or alleged to have been a child in need of care in the last 5 years.
Okay. We'll discuss.
If that makes sense. And then another thing the Senate was looking at was, again, we want the Office of Child Advocate and the Child Advocate to be focused on investigating cases and alleged cases of where the system is otherwise failing children. And to do that, we also want to have the child advocate, the office not be, I kind of look at the, devil's advocate side of things. And if we have an ex spouse who's trying to create trouble for the other ex spouse and involving the kids and making reports that aren't necessarily, backed up by fact, we want to make sure that the child advocate is able to discern what are the real allegations and what aren't, what are just, harassing the person you're reporting on or things like that. So to have some ability to do that. And to do that, I think we need to put some guardrails on the privilege and absolute immunity that a potential person making these allegations, you can't just call and make up allegations about somebody just to cause them trouble with the Office of Child Advocate. So it's a delicate balance, I understand, but to provide absolute immunity would not give any recourse for those kinds of allegations that are found to be baseless, if you will. So I would ask the revisor if we could tighten up and put together a balloon for the House to consider that would tighten up and help define the privilege and immunity for both the person reporting this and I think what are the thoughts, I guess, on the child advocate? If the court deems it necessary, upon a motion that the child advocate would have to testify. What are some thoughts on that? If the revisor could put some language together that if the court deems it necessary, so it's not automatic that the child advocate is going to testify in any of these cases, but in the extreme cases that the court would deem we need the child advocate to testify, based on these factors, the child advocate could do that. So that's a lot of talking for me. It's just kind of addressing two issues that the Senate was looking at.
Where are you at in the bill?
So with the definition of child, that would be pages 1 of the bill. And again, if we're working off of 2070 as the base bill, that would be page 6 at line 39. Shall be absolutely privileged. And I think the revisor can give us a legal definition of what absolutely privileged means. He's laughing. I think he can.
I think that was an issue that I brought up last year as well. So
Okay.
we will take a few minutes. And did you have more to talk about?
No, I've talked a lot already, so I didn't know if you wanted to look at that and just agree in general, and we could have the revisor look at some language before we finalize any agreement on that. But
you okay with that? Okay. Let's go ahead and have the language drawn up so that we know what we would be agreeing to. So
sure, the revisor could do that.
Okay. So while we're waiting on that, I think I'd like to visit a little bit about a few things that we discussed last year, where I feel like the Senate bill is vague on several issues, and one of those is the qualifications. Let's see. I haven't.
Is that page?
Page 2, looks like line 4 through 9. That's the area where I feel like it's vague, and would like a little bit, if we could look at the House bill on that for a little bit more specificity. I'm not sure that this side by side has qualifications, but
I think it's
there's,
on page 3 of 2443, and maybe the bottom of page 2 as well. Yeah.
these are qualifications too.
Oh, to be on the board. So, well,
No, to be for the advocate.
okay. In 2443.
Yeah. Well, I'm just throwing out a few things for your consideration. Also, if we could look at,
Because the Senate does already have some. It says no former or current executive or manager of any program or agency or contracting entity subject to oversight by the office may be appointed to the position within 12 months. But did you have some others in mind? Page 6 of 2443.
those are responsibilities.
I think if you're looking at
Qualifications.
2070, to the extent that there are qualifications listed, they're on page 2.
Yeah.
And it does say shall be selected without regard to political affiliation as well.
Okay, there's a reason why I have this note, so I may have to get back with you on that. Okay, where is that? Okay, I'll have to look for that. Okay, another thing I would like to know is on page 7, line 4, there's a reference to final result. I do not know what that is. Can you give me some kind of explanation?
Sure. Thank you. So on page 7, line 4, that subsection talks about the office conducting or participating in any investigation of a complaint shall disclose the final result of the investigation with the consent of the child or child's legal representative. And the Senate's thinking on this would be, well, we've got the child advocate either conducting the investigation or participating in the investigation of a complaint, and we don't want it to be for nothing. So if the final results of the investigation needs to be shared, it could be subject to the consent of the child or child's legal representative. Because remember, the child advocate is going to be looking into records, maybe talking with folks, and we want kind of the final result to be used for good purpose, right? Not you've done all this investigation and you have looked into it, and then you're not able to do anything with the final result. So the purpose of that is that you may disclose it if you need to disclose it to police, or if you need to disclose it to a parent or another caregiver. Again, subject to, because we're trying to balance, the authority to properly investigate and protect kids, and then keep it, because this is a lot of sensitive information, to keep it confidential as well. So with the consent of, it would probably be the child's legal representative, because if you're 10, you're not really going to be able to do that. But that's the purpose of, to be able to share the final result of, you've undertaken this, and we want to be able to be helpful.
Okay. Thank you for that clarification. So back to qualifications. I was looking for the word qualifications, but on this sheet that you just received, the second area is child advocate position requirements and restrictions. And the 2443 is a person that either holds a current relevant license that would authorize the individual to work as a licensed professional, as a case manager, behavioral health professional, or attorney for a child in need of care, or has 7 years of experience. So this is what I was looking at, that says much more specifically what qualifications would be required to be hired for that position. The This 2070 is a little bit more focused on what's prohibited for that position than the House position. But we've already talked about the prohibition in the in 2443, that's no current employee within the past 12 months. So just what if you would look at that language.
So is the House proposal to add in the language that you've just recited about requirements and prohibitions in 2443, to add it into 2070 on page 2 that we've been looking at? Again, subject to a balloon from the reviser.
Yeah.
Let us confer for a moment.
Okay, go ahead.
Okay, thank you, Madam Chair. So the Senate will accept the House position on the requirements and prohibitions, but with this change on the prohibitions, when it talks about, and I'm looking at the language in the chart, when it talks about no current or employee within the past 12 months as an executive or manager or any, is it supposed to be of any entity subject to oversight by the office in the square? But anyway, our suggestion would be to clarify, again, because we're looking for clarification, that within 12 months of your separation from employment as an executive or manager or employee of any entity subject to oversight by the office. Just to clarify that, I think it just,
You would, after 12 months, you would.
well, however, they're probably going to have to rewrite it a tiny bit, but
All right.
within 12 months of your separation from employment with, do I have that right? Yeah. Because, yeah, either you've been, terminated, or you've left your employment. So just to be a little bit more clear, that would be okay with us.
All right, so back to my original comment on some of the vagueness in this bill. Also on regarding access to information. And I think that starts towards the bottom on House Bill 2070, bottom of page 3. The word access is actually used on line 35, but that whole area is that, according to my notes from last year, it's maybe meaning similar, but the language is different than what's in the sync code. And so it causes a little bit of confusion. So I wonder if you would consider cleaning that language up a little bit. And I don't even know that we have where the language is in the House version, or if we just want to have consider. Actually, consider taking the language from the sync code. Page starts on the bottom of page 3, yeah, line 35. And you know, while I'm looking at that, at the end of page of line 34, establish and implement procedures for investigating complaints. I would like for that to be a little more specific and complaints related to child welfare. Child welfare.
So is the House proposal then adding language to line 34 in page 3 related to child welfare, and then on access line 35, some sort of, on line 40, all records as established in or defined in, and the sync code that's chapter 38. Is that chapter 38 we're talking about?
Yes.
Or
Yeah.
Okay, is there a subsection of chapter 38? Is it 2201?
Can we allow him to pull that language together for us?
Yes, in a balloon. Yes. Well, we'll need to confer here on the Senate side of things. Just a moment. The Senate accepts the House position on that.
Throw one more thought out there for your consideration and discussion. We really have a problem with the subpoena power. Our bill does not include any subpoena power whatsoever. Yours allows it. I just wonder if you would consider our position.
Which is what? None at all?
Yes.
Well, the Senate has a position that I think you're looking on page 4 of the bill 2070 about the authority of the child advocate to subpoena materials or witnesses. So that's a pretty important authority to be able to do this investigation.
Okay, we will have to talk about that a little bit, but I just think that it's just way too much power for one person to have. It According to my notes, well, first of all, we don't need interrogatories on line 21. There's nothing in here that says that it needs to be related to child welfare or the Office of the Child Advocate, there's nothing that indicates a response time. We need that to be specified. There's no procedure in getting it. There's no mention of confidentiality. So I'm asking for you to take a look at that and make it a little more specific. Is that what you're trying to tell me? Okay, we've got to go vote. What, so we are on the floor now, and I assume again at 4, and I know you have other people to conference with. Is there a time that you could meet yet today?
Thank you. And we do have a conference committee, Senate Judiciary Committee does with House Judiciary upon recess of the second chamber after 2 o'clock. And then so let's possibly meet or recess here until 4, or we're back on the floor at 4. You want
Back
to
on-
try 3:30?
We will probably calendar at 3:30, but let's go ahead, recess till 3:30, and don't tell my leadership we're skipping calendar. No.
Do we have this room at 3:30?
That would be a Judy question. Okay.
But we'll make an
I'll look
announcement.
into
We'll
it.
notice it.
Yep.
All right. Thank you.
All right. Thank you. Recess till 3:30.